Hi, students. So this short video lecture is Unit 3, the authority to detain and arrest and use of force. We're in week 6. Week 6, and this video is on law enforcement contacts with people in the community. When we talk about law enforcement contacts with people, there are only three. There's a consensual encounter, a detention, and an arrest. A consensual encounter has to be voluntary. The person has to be free to go. Detention has to be supported by reasonable suspicion, and an arrest has to be supported by probable cause. It's absolutely essential that officers understand these three contacts and what has to be shown um, to establish a valid contact. So regarding consensual encounters, a consensual encounter has to be voluntary. The person has to be free to go. So does an officer need any sort of reason to engage a person in a consensual encounter? The answer to that is no. A police officer can walk up to anybody, anytime, and engage in a consensual encounter. How is that typically done? It's typically done by the officer asking the person if they can talk to him. So the officer would say, "Hey, can I talk to you for a second? Hey, do you mind coming over here and talking to me?" Something along those lines. And if the person consents and it's voluntary, then that officer has engaged in a consensual encounter. Other types of consensual encounters, if you call 911 or you contact a police officer for help, you are asking and seeking their help, then that would be a consensual encounter. So a consensual encounter has to be voluntary. The officer does not need any reason whatsoever to engage in a consensual encounter. The person is free to go. They have to be free to go. Now, what can be done during a consensual encounter? Well, anything the person consents to. So if the officer says something like, "Do you have any contraband on you?" and the person says no, and the officer says, "Well, do you mind if I check?" and if the person says no, go ahead, then that's a consent. That's a consensual encounter. That's a consent to search. That's perfectly lawful. What if you're not sure? What if you're not sure if you're a person you're contacted by the police and you're just not sure? um, then then you should ask the officer. Be polite. Don't get in their face. Just say, "Officer, I'm not sure what's going on, but am I free to go?" And if the officer says yes, you're free to go, then you decide, do you want to leave or not leave? If you're free to go and you want to go, go, right? But if the officer tells you no, you're not free to go, then the officer has most likely detained or maybe even arrested you. But definitely there's been a seizure. So you don't have to justify the engagement of a person when you're doing a consensual encounter. You don't need a reason for it. You can do anything the person consents to. Can I take your photograph? Can I look at your tattoo? Can I search you? Ask questions. Where are you going? Where are you coming from? There's a lot of reasons to engage a person in a consensual encounter. When I was a police officer and I worked a beat and I saw someone on my beat that I did not know, I didn't have any reason to detain or to arrest them. I would just engage them in consensual encounter. Can I talk to you for a minute, Patty? Oh, sure. Where are you going? Where are you coming from? What's your name? And then I would run them for warrants. And can I search you? I would just it's a tool that an officer can use if they're smart about it. And officers are out there, day in and day out. They're constantly talking and dealing with people. And a consensual encounter is a great way to find out, who they are and what they're doing, and especially if they're on in your beat. It's very important that officers do that. They have to be proactive. They shouldn't be reactive. They should be out there actually engaging the community. That's part of their job. Um, what about a detention? A detention has to be supported by what? Reasonable suspicion, I said. And we're going to get into detention and arrest, but so I'm not going to cover that in this particular lecture. An arrest has to be supported by probable cause. But I do want to cover this concept, and that is, when is a person seized? Now, in a consensual encounter, guess what? The person has not been seized. It's voluntary. They're free to go. They have not been seized, right? Because they have not been seized, then it does not have to be justified under the Fourth Amendment. The only time that you have to justify a contact under the Fourth Amendment is what? Is when the person has been seized by law enforcement. If you've been seized by law enforcement, then that triggers the Fourth Amendment, and it has to be justified under the Fourth Amendment, and you have to meet the requirements of the Fourth Amendment. So when is a person seized? When does that officer cross the line, say, from a consensual encounter to a seizure? There's two ways. A person is seized when the person submits to authority, or the officer uses any kind of physical force. If the officer uses physical force, grabs the arm, grabs the hair, blocks them, hits them, uses a stick, maces them, whatever. If they use force, the person has been seized. It has to be justified under the Fourth Amendment. The other way is when the person submits to the lawful authority of a police officer. So instead of the officer asking, "Can I talk to you?" the officer says, "Hey, you, come here. Sit down. Don't leave. Move over here." If the officer starts giving commands, "Hey, you, stop." If the officer starts giving commands to that person, and that person submits to those commands, then that person has been seized. The officer is not asking, the officer is telling that person to submit to my authority, basically, and the person submits, then that person has been seized, and that seizure has to be justified under the Fourth Amendment. So again, when a person has been seized, then the law will classify that seizure of that person either as what? A detention, which again has to be supported by reasonable suspicion, or they'll classify it as an arrest, and then that has to be justified by probable cause. Very important for officers to understand that. I want to give you another example of a consensual encounter, and that's the Drayton case. That's a case that I call Dumb and Dumber. And in that particular case, Dumb and Dumber, it's a drug interdiction case, and it's at a bus terminal. The bus, like Greyhound, has made a stop at a bus terminal to take a break. It's a long distance trip on a bus. And so when the bus stops at the terminal, the bus driver gets off to take his break, and these officers that are assigned with drug interdiction enter the bus, and there's three of them. One goes to the back of the bus and is standing there for security purposes, officer safety purposes. There's one in the front looking back to the back, also for officer safety. And the third officer starts at the back, works his way forward, and talks to each passenger. They're dressed in police type utility uniforms, clearly identifying them as police officers. The officer that's talking to the passengers is very low key, identifies himself, identifies what they're doing, and asks them where they're going, and if they have any baggage, and if he can search. So he approaches the person I call Dumb and contacts Dumb and says, where are you going, and do you mind if I search? Now, Dumb has a bunch of dope on him, but the officer asks him, and Dumb says, yes, go ahead and search. Well, the officer does, finds the dope, and arrests Dumb. Now, Dumber, his partner, sitting right next to him. Dumber just witnessed what happened to Dumb. And the officer then turns to Dumber and says, can I search you? Dumber Dummer has a bunch of dope on him. What does Dummer do? Does he say no? I would have. I mean, I just saw my buddy get arrested after he said yes. So, but Dummer says, go ahead. I guess Dummer wanted to go with his buddy because when Dummer was searched, they found more dope, and Dummer ended up being arrested. So when they're arrested, they're going to be booked, and then they're going to be charged. Now, this is something that's very important that you need to understand. They're charged, and they want this evidence to go away legally. So what happens is the defense attorney makes a motion to suppress. Now, usually that is done in writing. It's filed in court. It's served on the prosecutor. The prosecutor typically will respond in writing. There is a hearing before the trial. It's done before the trial. It's a hearing on the motion to suppress. Now, if this search and seizure was with a warrant, then that search is presumed to be lawful, and the burden would be on the defense to show that it was unlawful. That's if they had a warrant. But in a case like this, where they don't have a warrant, the burden is going to be on the prosecution and law enforcement to show that it was a lawful search and seizure. So that means who's going to get called to the stand? You. If you're a police officer, it's your case, you're going to be called to the stand. You need to know what you're doing because you're going to be asked about it, right? So in this particular case, that's what happened, and the court ruled that it was a consensual encounter, denied the motion to suppress. The person, Dumb and Dumber, they're convicted. This goes all the way eventually up to the U.S. Supreme Court. And the U.S. Supreme Court agreed with the people and said, no, this is a consensual encounter. They consented to the search and to the seizure, basically. So the conviction was upheld. So that's an important thing to note. During a consensual encounter, it has to be voluntary, but if it's voluntary, it's going to be upheld. But again, the burden is going to be on the officer to establish that. Now, let me give you an example of a case in my court. So there's a motion to suppress some evidence from a kid. It was some pot, I believe. But anyway, so it's going to a hearing. There's no warrant, so the officer is going to have to justify it. So the officer takes the stand and says, well, it's a consent to search. Okay, so what did you say to the to kid, or what did you ask the kid? And the officer goes, or deputy says, well, I don't remember. And so then the question, well, what did the kid, how did the kid answer your question when you asked your question? And the officer says, well, I don't remember that either. I don't remember what I asked the kid, and I don't know what the kid said back to me. Do you think from that testimony that the prosecution, the people, law enforcement justified what happened as a consensual encounter? No, they did not justify it. So the motion to suppress was granted. I suppressed all the evidence and the case was dismissed. Now, when a motion to suppress is granted, it only suppresses the evidence. It doesn't dismiss the case. So if there's some evidence that's left still in the case, then that case can go forward against the defendant. On the other hand, if all the evidence is gone, then most likely the case will be dismissed. If it's dismissed, then the people can appeal the court's decision. If the motion to suppress is denied and the person is convicted, just like the case of Dumber and Dumber and Drayton, then the defense can actually uh, appeal their conviction on the grounds that the trial court made a improper, unlawful ruling on the motion to suppress. I hope that is clear to you. So if not, listen to it again, think about it, you can ask me questions, okay? So those are the three contacts. Consensual encounter has to be voluntary, a detention and arrest, which are seizures, and then they have to be justified, of course, reasonable suspicion to detain, probable cause to make an arrest. And that's important, okay? And then what'll happen if it's if once there's a contact and if there's evidence and there's a motion to suppress, how that works as well. All right, that ends this lecture. I will see you soon. Until then, stay safe. Thanks. Bye.